Hi, I'm immigration attorney Heather Poole. I'm speaking to you today about the common mistakes made in unlawful presence waiver cases, which are commonly known as the 3 and 10-year bar. I suggest you start with our first video on this subject in this series, as we're already into mistake number 4 on this video. For a description of the 3 and 10-year unlawful presence bars, watch our video entitled 3 and 10-year bars for more information. Remember to always consult a licensed, experienced immigration attorney before filing for any relief, and if you're in this situation. Mistake number 4, making conflicting or incomplete arguments for hardship. In my practice, to keep apprised of what immigration decides when reviewing appealed hardship cases, I often read CIS denials from cases filed by other attorneys. There's a common theme in many of these denials. The applicant uses conflicting arguments. You must play the devil's advocate role in reviewing your own case to prove extreme hardship to your spouse or parent. Do any of the arguments that you've presented conflict with each other? Many of the denials also indicate that the hardship arguments are incomplete. The immigrant tries to make the argument but misses because it hasn't covered one side of the coin. There are two sides that immigration looks at for determining hardship to a U.S. citizen spouse or parent, or permanent resident spouse or parent. They want to see that the U.S. citizen or LPR relative cannot stay in the United States without the immigrant. And then you also have to argue why the U.S. citizen or permanent resident spouse can't move abroad to the immigrant's home country and live there. Mistake number 5, submitting long letters by U.S. citizen or permanent resident petitioning spouses or parents that are not supported by evidence and are not organized by argument. This is a very common mistake. People filing cases by themselves or with attorneys who are not experienced with waiver cases often put all the emphasis on the hardship letter itself and no emphasis on the actual evidence to support the letter. The evidence should be your main focus, and the hardship letter should summarize this evidence. Mistake number 6, failing to supplement your case with new evidence if substantial new arguments exist while the case is still pending. In Mexico, for example, there is a boilerplate letter that is sent to cases that are put in the backlog. It allows 30 days for an immigrant to supply additional documentation to prove hardship. There's no legal requirement that you only have 30 days to respond. After any waiver submission anywhere in the world, you can continue to document the case with new arguments and new evidence until the point that your case is decided. It is always best practice to ensure that your best arguments are presented in the initial filing, however, because there's no guarantee that additional documentation will read well with the rest of the arguments that you initially made, and you also risk that the evidence will not reach the actual file in time, especially when some offices subcontract with other offices and send the actual file out. Mistake number 7, comparing your waiver case to others. Everyone's facts are different. Waiver cases are heavily based on facts. The arguments could be completely different, and any evidence submitted could be completely different. Do not compare your case to others for your own sanity. Mistake number 8, micromanaging your attorney and failing to use a competent attorney. Make sure that you hire an attorney who has actually done waivers before. There are many attorneys who won't do waivers at all because they're worried about the U.S. citizen petitioner being alone in the United States without the immigrant, alone and angry if the waiver is not successful. If the attorney does not wait and doesn't file waivers regularly, they're less likely to know what documentation and arguments to present to immigration. Be careful about dealing with attorneys who claim they can do your waiver case for $1,000. They're not putting much time into your case if this is all that they're charging. Attorneys charge on an hourly basis, and they give you a flat fee based on how many hours they would spend on your case. Someone who charges $1,000 for the entire case is likely spending less than 4 hours on your entire case. This is not enough time, and this is not the time for you to pinch pennies or save money. To give you an example, in our office, cases usually take upwards of 80 hours to complete. If you could be separated from a loved one for many years, this is not the time to be cheap or try to find the best deal. You need to find the best attorney. You tend to get what you pay for in life. The same is generally true of attorneys. Investigate your attorney and make sure they know what they're doing and that they have experience with waiver cases. Many of our clients have a lot of anxiety the closer it gets to waiver submission and the immigrant visa interview at the consulate. This is very understandable because you have a lot on the line and are facing potential separation from your loved one. Do not enter into this process voluntarily if you do not think that you can emotionally handle it. This can be a very stressful process. Always consult a competent immigration attorney to determine if any action can be taken for you to legalize your status and what your chances would be if you apply for one of these unlawful presence waivers. Waivers of the unlawful presence bars are one of our main practice areas. We have additional information on our website about the bars. There may be other alternatives for you that are not discussed in this video. If you need my help, feel free to call us or contact us through our website, humanrightsattorney.com. Thank you and good luck.